Is anyone all set? You good, team? All right, let's begin. Quote, over 15 years after the worst terrorist attacks in American history, 5 of the men accused of planning the assault still haven't faced trial, conviction, or execution. They're supposed to be judged by a military commission at Guantanamo Bay, Cuba, but that trial hasn't even begun. Many of the soldiers who now guard the 9/11 terrorists at Gitmo are too young to remember when the plane slammed into the World Trade Center. If the accused 9/11 plotters had been tried in a federal court, they would be on death row as we speak. The facts are clear. Military commissions have become a roadblock to the process of justice. For this reason, my partner and I stand resolved that the United States federal government should substantially reform its foreign policy regarding international terrorism. As with any federal policy, the U.S. should value a substantial interest. Therefore, our goal we'll be presenting for today's round is justice. Justice for the sake of the people, and also for the sake of our government. Our first and only definition will be foreign policy. Dr. Charles Herman, who has served on the National Security Council, the Council on Foreign Relations, and the American Political Science Association, wrote, quote, foreign policy consists of the plans, the goals, and actions of national governments directed at entities outside of the nation. Quote. Herman goes on to explain how there may be many ways to define foreign policy, none of which are necessarily correct or incorrect, but that it simply depends on the context being used. Let's examine the background of military commissions now for our facts. Fact 1 is established to try international terrorists. The Office of Military Commissions explains its own history. Quote, after the terrorist attacks on September 11, 2001, President George W. Bush established military commissions to try certain individuals. The President's military order authorizes trial for non-U.S. citizens who are or were engaged in acts of international terrorism that have caused injury to or adverse effects on the United States. Despite the original intent to be effective at punishing terrorists, military commissions in practice are considered disastrous, as seen in Fact 2, opposed by experts. In May of 2018, the American Bar Association released a report compiled by 24 national security and law experts, including law professors, judges, and several former military officers. While these experts were diverse in their occupations and in political views, the report states that, quote, all believe that whatever their original intent and design, the military commission system at Guantanamo is not working as intended. They should either be reformed or terminated in the interest of U.S. national security and justice for the families of victims of terrorism. Unquote. Bobby Chesney, a law professor at the University of Texas, does well to explain this criticism. Quote, relentless pressures over the past 16 years have led to so many revisions to the rules for these commissions that the procedural advantages that they were designed to confer have largely disappeared. Unquote. At the start, military commissions allowed many practices involving evidence standards and treatment of detainees that distinguish them from federal courts. However, reforms put in place in 2006 and in 2009 amended a massive number of these practices. The Office of Military Commissions noted on their website that, quote, the 2009 Military Commissions Act expands the rights of the accused to align more closely with the rights afforded to an accused in court-martials or in federal criminal cases, unquote. This basically invalidates any differences that military commissions may have once had. Because military commissions don't work as advertised, they are counterproductive to justice. That's why Abby and I propose the following plan. Mandate: military commissions will no longer be used to try international terrorists. Cases concerning international terrorists will be exclusively handled in federal courts. Section 1033 of the National Defense Authorization Act of fiscal year 2019 will also be repealed, which would allow the United States to transfer terrorists from Guantanamo Bay and also be extradited from other countries. These steps allow federal courts to handle all cases involving international terrorists and eliminates the possibility of an ineffective and unjust military commission proceeding. Agency and enforcement will be Congress, the President, the judicial branch, and any other necessary bodies. Timeline will be 1 year after the passage of an affirmative ballot, and funding will be through normal budgetary means. Additionally, the affirmative team reserves the right to clarify this plan throughout future speeches. Let's now examine the advantages of Article 3 federal courts through our justification. Justice. Justice is the primary goal of our plan, and federal courts best meet that standard. There are two subpoints under this. Subpoint A is efficiency. Efficiency. Since 2001, 8 terrorists have been convicted under military commissions. During that same time period, over 660 terrorists have been convicted under federal courts. As Bobby Chesney states, quote, "It is evidence of capacity and of competence. When it comes to actually and fairly processing criminal cases, nothing compares to the combination of Justice Department prosecutors, federal public defenders, and the judges and staff of the Article 3 federal courts." Unquote. Not only do federal courts convict more terrorists, they also do so more quickly. As Huffington Post reports, quote, "We analyzed the length of time between crime and sentencing for more than 24 prominent alleged terrorists captured by the US government in the past 2 decades. In every one of those cases, the federal court system took less time to convict the captured terrorists than the military commission system at Guantanamo has taken to even start trying the accused 9/11 plotters." Unquote. This idea of efficiency becomes far more important once you combine it with subpoint B. Just deserts. Just deserts. A massive advantage to federal courts is that they draw authority from both US criminal law and military law. In contrast, military commissions are limited to only trying terrorists under military law. This means that since the 2009 reforms, military commissions have had only 32 charges at their disposal, while federal courts have had access to over 4,000 charges. In one case, the chauffeur of Osama bin Laden, Salim Hamdan, was convicted by military commission of material support for terrorism. At first, he received a paltry 5-month sentence, but on top of that, his conviction was completely overturned because material support for terrorism was determined to not be a chargeable offense under military law. On the other hand, Ali Assad Shandia was convicted in a federal court under the same charge, material support for terrorism, in light of him helping a Pakistani extremist mail equipment to his allies. Shandia was sentenced to 15 years. If giving terrorists their just deserts is important, then look no further than federal courts. The reasons to pass our plan are simple. Federal courts are proven to reach convictions efficiently and ensure just deserts, while military commissions have proven to be a far cry from their original intent. A reform is needed to address the arbitrary and flawed nature of the current system and perhaps finally convict the 9/11 conspirators that have been in limbo for far too long. We ask you to stand with the experts, the facts, and the families of victims by reforming the current system in the interest of justice. Thank you. I now stand open for cross-examination.